One question that I get asked a lot is, what is probate? Probate is an old term. It's now called a certificate of appointment of a state trustee with or without a will. This is the process of formally appointing your executor to administer your estate, as well as the process of proving a will to be valid. It involves an application to the courthouse wherever the deceased was residing at the time of their death. The application includes information about the deceased, information about the beneficiaries and executor, the date of death value of the deceased's assets, as well as the original will. The court will review the application. They'll make sure that the will meets all the legal requirements of a valid will. Is it dated? Is it signed? Is it witnessed? Once approved, the court will issue the certificate of appointment of a state trustee. The executor or estate trustee can then take that to financial institutions or other third parties to help start liquidating the estate. The second part of the application is the estate administration tax, formerly known as probate tax, which is roughly 1.5% of the value of the estate. The probate process is not automatically triggered when someone dies. It depends on what the assets of the deceased were at the time of death and how they were held. So for example, some assets that are held joint, some assets that have beneficiary designations like RSPs, tax-free savings accounts, life insurance, or pensions, do not fall into the estate and then don't need to be included in the probate tax calculation. Typically, banks will ask for a certificate of appointment because that certificate gives them the comfort that they're dealing with the right executor, the right deceased, and the right will. But it's not always necessary. There are some exceptions, and it may be possible to get around probate, which is why it's important to check in with your will and estate planning lawyer to see what can be done for you.